We represent a lot of condo boards and co-op boards with their usual corporate issues they have with their with residents in the building, whether bylaws are being observed or not. And we also represent the other side of that coin. We represent individual co-op shareholders and condominium owners who have problems with the rules and regulations of the boards. Sometimes a lot of boards act sort of arbitrarily, and our clients have problems and we need to take care of them. I also am involved in what I guess are more complex litigation real estate cases, involving title issues, mortgage issues. And I think that the real turning point for me came in 2009 when following the financial crisis, a lot of people that had signed contracts to purchase condominiums realized that the value of what they had purchased was going to be less than what they were actually committed to pay. And Adam and this firm, we discovered something called the Interstate Land Sales Act, which had been passed as a relief act for condominium owners sometime in the 60s, and had really been overlooked and never used in all that time because real estate markets kept going up and up. The act, the federal statute, had very strict requirements of disclosures that had to be made to purchases of condominiums. And of course, in New York, condominium capital of the world, basically at that time, and I think still is, the offering plans had overlooked the requirements of the statute. So we made use of that statute, and we brought a number of cases. We weren't the only firm doing it, but we were fortunate enough to get some of the very first rulings that favored the condominium purchaser. It was like a revolution that occurred. Now, as a result, we won a number of important decisions, and the decisions themselves were not as important, other than the fact that we obtained them, but because of the emphasis that was made on Interstate Land Sales Act and the focus that was given to it, we were able to obtain a lot of settlements for our clients. And we probably got more settlements out of this than actual litigated cases. But since then, of course, Congress amended the statute, and that's something that's not going to be heard of again. But my point is that when we did those cases, we took this issue on. It was a challenge, a legal challenge. First, people that we talked to, that even lawyers in our own firm that we mentioned what we were going to do, they thought we were crazy because it went against the grain of everything people understood about real estate law and purchase and contracts of sales. So we were successful. But my point is that it was like a turning point for this firm. You could see almost immediately how the firm was considered on a higher level. We had gone to that higher level, and we've not really stopped since then. Clients come to us that have unusual problems, problems that are complex and that require a lot of intellectual, I guess you'd call it brainstorming. What are the best things we can do for this client? What are the things in the law that may not have been used before that we can use for this client? How can we convince a judge that our client has really been wronged and the law should work in his favor, not against him? Well, there are many firms and many attorneys that do that. There are others that shirk away from the hard type of cases, cases that may take a little bit longer to complete. Cases that require a lot more, let's call it legal sweat equity, to really understand, to discover the key to a case that's going to make it win or lose.